Hello and welcome to my presentation. Today I will be critically analysing the law around easements. Before we begin, it is worth noting what an easement actually is. An easement is defined in Halsbury's law as a right annexed to land of different ownership to do something on the land or to prevent the owner of the other land from utilising it in a number of certain ways. The main areas of discussion that I'm going to be addressing today are Section 62 of the Law of Property Act 1925, implied easements and the ouster principle. Section 62(1) of the Law of Property Act 1925 provides that a conveyance of land shall be deemed to convey and shall operate to convey with the land all privileges, easements, rights appertaining or reputed to appertain to the land at the time of the conveyance. But the effect of this provision is that it converts any rights, privileges or advantages enjoyed by the occupier of a dominant tenement before the sale or the lease of the land into legal easements. A prime example of where Section 62 is being used is shown in the case of Wright v McAdam in 1949. In this case, the Court of Appeal held that the grant of a new tenancy amounted to a conveyance under Section 62, and as a result, a mere licence of storing coal into a flat was granted as an easement. One of the major problems of Section 62 is that the effect of the provision of turning rights and privileges into easements can go against the intention of the parties, as they may never have intended to create a legal easement. The Law Commission provides in their report that the provision often operates in circumstances where the parties would not necessarily expect an easement to be created. This again highlights the effect of the provision which automatically creates easements where the parties may never have wanted them. A reform in this area was put forward by the Law Commission, for which they provide that we recommend that Section 62 of the Law of Property Act 1925 shall no longer operate to transform precarious benefits into legal easements or profits on a conveyance of land. So what this means is now that Section 62 will no longer make precarious benefits such as licences into easements. They will just merely carry over existing easements and keep the precarious benefits as they are before the conveyance. The first method of implication is through necessity. Sterling Law Justice at 573 in the case of Union Lighteridge Company v London Graven Dock Company provided that an easement of necessity means an easement without the property retained cannot be used at all, and not one merely necessary to reasonable enjoyment of that property. The second method of implication is through common intention. In the case of Wong v Beaumont Property Trusts, it was held that the parties intend to use the premises as a restaurant. In order to do so, would need to install ventilation. The third method of implication of easements is under the rule of Wilden and Burroughs. This applies to quasi-easements if the common ownership is sold as an express grant, if the easement claimed is continuous and apparent, necessary to the enjoyment of the property sold, and in use at the time of the grant. The fourth method, which is under Section 62 of the Law of Property Act 1925, was addressed above and will not be commented on any further. The law around implication of easements is overly complex as a result of there being 4 different methods. The Law Commission has argued that the law is overly complicated and difficult to apply. There is an unnecessary overlap and omission due to there being 4 different methods. So this again highlights the problems that there are by having 4 different methods, as there is a confusion around which method applies where. In terms of reform, the Law Commission have proposed that the enactment of a new statutory test for implication should be enacted, where the only question that would need to be asked is would an easement be necessary for the reasonable use of land? This would make the law around implication of easements a lot less complex and a lot easier to understand. The next area of discussion to look at is the ouster principle. The ouster principle means that a person must ensure that the right that they claim does not prevent the servient owner from using his land altogether. One of the cases that shows the use of the ouster principle is London and Blenheim Ltd v Ladbroke Parks Ltd, where it was held that the right to park a car was acknowledged as the servient tenement had reasonable use of his land. This decision was followed through in Batchelor v Marlow. However, a different approach was taken in Moncrief and Jameson, where it was held that the test should be whether the servient tenement retains control and possession of their land rather than the reasonable use of their land. One of the problems with the ouster principle is that it does not provide a fair balance between the rights of the dominant owner and the servient owner. Gareth Spark in his article provides that the law of easements must strike a fair balance between the rights of the dominant owner and the rights of the servient owner. It appears that neither the reasonable use nor the possession and control test does this, as each seems to focus only upon what the servient owner cannot do on his land. One method of reform for the ouster principle is to acknowledge easements as a possessory interest in land to allow them to become an interest of joint possession rather than exclusive. Gareth Spark in his article provides that it is time to abandon the putatively fundamental principle that easements are non-possessory interests in land so long as it does not overly restrict the servant owner's practical ownership of his land, and is thus not a claim for exclusive possession. This again would provide a fair balance between the rights of the dominant and servient tenement's own rights. To conclude, I have analysed 3 aspects of the law of easements that are in need of reform. The first area that I have analysed is section 62 of the Law of Property Act 1925, which is in need of reform as to prevent it from creating new easements which do not reflect the intention of the parties. The second area that I have analysed is the law around the implication of easements, which is in need of a new statutory provision governing the implication laws in order to avoid the complexity and confusion of the law. And the third area that I've analysed is the ouster principle, which needs to be able to confer joint possession in order to strike a fair balance between the rights of the dominant and servient tenements. Thank you for listening.